It is not the first time such inheritance rulings have been made. Indeed, many rulings in favor of women have been made even before the current constitution came into force in 2010. Our very own Enock Sikolia reports on the ruling, which seems to have come head-to-head with customary practice.
A Nyeri court ruling has put married women in the bracket of those eligible to inherit properties left behind by their late fathers. In a nutshell, the court allowed women to be included during the distribution of wealth among the dependents of the deceased. Indeed, this ruling, made approximately 150 kilometers away from Kenya's capital, Nairobi, is stirring up debates in towns and villages hundreds of kilometers away.
Ni mzuri, diposa at least hata kukiwa na hiyo shinda mahali ambapo wameenda, akilundi ajue kuko na mahali amelundi pamestahili na kuko na mahali amelundi palipo kwake.
The ruling is not the first of that kind. On the 17th of February 2011, Judge Mary Kasango ruled in a succession case that it does not matter whether a daughter of the deceased is married or not when it comes to consideration of whether she is entitled to inherit her parents' estate. She said in part, Article 60 of the Constitution of Kenya 2010 provides for elimination of gender discrimination in respect of land. The marital status of a daughter is not a basis to deny her the right to inherit her father's estate. She was ruling in a case of one Consolata Tibuka, who had challenged her brother's decision to evict her from her late father's land at the High Court in Meru.
In the past, we have dealt with our land based on customary and traditional rules, and it makes the point that those traditional rules must be aligned to the Constitution.
Even before passing of the current Constitution, courts invoked the law of succession to guarantee daughters property rights. According to Lady Justice Martha Koome, when ruling in the case of Priscilla Kamau in 2005, daughters, just like sons, have equal rights to inherit. The law does not distinguish between the children of a deceased on the basis of their gender or marital status. Once again, a court ruling in Nyeri is stirring up a debate between observers of the Constitution and traditionalists. The contestation is based on the dictates of the African traditions. Traditionalists believe that daughters have no property rights as envisaged in customary laws. According to culture, daughters should live in areas where they are married and leave inheritance to their brothers.
Katika mila wa Bukusu, sisi tunataka kushikilia mila zetu. Maneno ya kuharibu mila imefanya kila kitu kimeharibika katika jamii.
But according to Odote, reality is now sinking that the cultural tradition of locking out daughters from inheriting their parents' property is outdated.
We are looking at the land that this community had, and that land was not just available to the individual, it's available to the community. So somebody is saying if you move to another community, then you should be integrated into that community. You should not be coming to claim the same land that...
Enock Sikolia, Citizen TV, Nairobi.